Thank you. It's a pleasure to be here at Adams State today and to be part of the panel that will be addressing the important issues about oil and gas. By way of background, for the first 20 years of my practice, I represented the industry in their dealings and litigation with one another. For the last 15 years, I've represented exclusively surface owners and municipalities and public interest groups in dealing with energy issues, and in particular issues involving oil and gas. Today, unfortunately, I don't want to talk about fracking until we get into the panel discussion. I think there'll be a lot of opportunity to answer questions about that. I thought it would be informative to talk a little bit about property rights and how those property rights are impacted by oil and gas development. So I'm going to do that. When I say property rights, people usually associate it with landowners, but really there are three basic property rights that we have to look at. When you're in an area of potential oil and gas development, the first is the owner of the surface estate. The second is the owner of the minerals. It's called the mineral estate. And the third is whoever leases those minerals from the owner of the mineral estate, usually the oil company. Now, the surface estate and the mineral estate may be the same, or they may be different. Frequently, the mineral estate's owned by someone else, other than whoever owns the surface. And a lot of times it's the federal government, and other times it's private individuals. How these estates work together is exceptionally important. First, let me tell you a little bit about how it all came about. It was several hundred years ago in England. The law came down, I think a bit unfortunately, saying that the mineral estate is the dominant estate, and it can use the surface to develop the minerals. Back then, there wasn't oil and gas, but there was a lot of mining. And as that law developed, nothing particularly came out of it that said when that surface area is disturbed, the surface owner has to be compensated. Now, that law carried forward into the United States, and even up to 1966, the Supreme Court of Colorado said that when oil and gas is developed, the mineral owner and the oil company, the lessee, doesn't have to pay anything to the surface owner. Very unfortunate decision in my view, but that's the law, and that's what we have to deal with. How that's changed over the years is through what's called the accommodation doctrine, where many states started recognizing the fact that excessive use of the surface for mineral development is probably not fair. So in most oil and gas jurisdictions, there's something called the accommodations doctrine, which in essence says that the mineral estate and the lessee, the oil companies in this case, can only use so much of the surface as is reasonably necessary to develop the mineral. This case was decided on the accommodation doctrine by the Supreme Court of Colorado in 1997, the Garrity case, which went into quite a bit of detail about what can be done on the surface of the property without causing excessive disturbance. In 2007, this was codified. It was codified in a statute that the Sierra Club and OGAP, the Oil and Gas Accountability Project, and others, and myself worked on. And that statute says that in extracting the minerals, the oil and gas lessee must accommodate the surface by minimizing intrusion and damage to the surface, and must employ alternate means of operations to minimize that damage. There's a catch to that, not necessarily a catch, but a qualifier, saying that to the extent that what's being requested of the oil and gas companies to do to accommodate that surface has to be economical to do, and it has to be technically feasible. Good statute Hasn't gone to court yet. I had a case last year that was that settled, unfortunately, the day before trial, so we didn't have a chance to get much case law on point. I think that's going to be expanded. I think as the case law develops, interpreting that statute, you're going to get not only decisions about how much of the service can be used and how it can be used, but I think you're going to get decisions on how the water and air have to be protected. So let me just go over a few examples with you, or a few situations in terms of what you as landowners need to think about. That's going to depend on your situation. It depends on whether you own surface, minerals, and whether those are leased. So the first situation is where a landowner owns both the surface estate and the mineral estate, and let's say it's not leased. That's a very lucky person, because you call all the shots. You don't have to let someone develop your property if you own the minerals, under no circumstances. So in that situation, you would certainly want to negotiate a very good lease. And if you're well advised to get someone that knows something about leasing before you do it. You usually get a bonus, cash bonus, usually get a royalty, and if an oil and gas landman comes to you, usually what they tell you that there's a standard form lease that's signed, a producer's 88, and it's anything but. They vary considerably, so get advice on it. And then the second thing to do, because you own surface, you need to get a surface use agreement. And that agreement describes what can be done on the surface, where the oil and gas operations take place, where the pipelines go, where the road goes, and any other restrictions that you want to put in that lease. If you own the surface and minerals, that's your choice. You make that as tough as you want to. If there is a lease in place when you already bought the land, and that frequently is the case, a lot of these oil wells last for 40 or 50 years, the oil and gas wells. And a lease is good for as long as there is production on it. So it's quite frequently that people find out that they own land, they buy the minerals, but it's subject to a lease. That's the case. The first thing you want to ask yourself, is the lease still good? A lot of times it isn't. A close examination of that lease to see if it's still valid. A lot of times the operator did not do what he was supposed to do during the history of the lease, and it may not be valid. And then, secondly, if that's the case, there are certain protections that the law provides to landowners and mineral owners, which would require the oil and gas company to develop the minerals in a prudent manner. And that includes the extent to which they drill out the property, as well as how they drill it out. Let's go to the other situation. Let's say you're just a mineral owner. If you're just a mineral owner, at least ostensibly, you don't have an interest in the service, but I think you should. A lot of times mineral owners will come to me and say, gee, I have this minerals, go ahead and lease it. I think the mineral owner has a duty to the surface owner to protect that surface. There are no cases on point, but I think it's implicit that if you have an estate that impacts another and you give free range to the oil and gas operator to develop that surface, I think there's some concerns about it. So if I have a mineral owner and I'm preparing a lease, I'll always put in the lease that mineral owner is not granting any more rights to the surface than he's legally allowed to do. And that is, the legal limit on that is the accommodations doctrine. No more use of the surface that is reasonable and necessary to develop the minerals. So I think that if you're a mineral owner and you live in a community, you have an opportunity to sort of make sure things are done right. Not only on the land in which you own minerals, but on the surrounding land. I think it's very important for the community to be progressive on it. And if that is the case, that mineral owners have a lot of stroke in saying what happens on their land and what happens on surrounding land. Again, if someone acquires the minerals and they're already leased, the same situation applies. Make sure a lease is still in effect, and make sure that the oil and gas operators comply with the current laws. which are more extensive than they were in the past in terms of what can and cannot be done. The third situation is the tougher situation. The situation where your landowner just owns the surface. Very tough. The law does not require compensation for that beyond what is stated in the lease. Generally, leases say they'll pay for crop damages, and the lands, the damage to the land is much greater than that. If you're in an urban area and you're a farmer and it's in the path of development, that land could be worth tens of thousands of dollars an acre. And the area surrounding oil and gas operations generally has a no-build zone of 350 feet. Well, a circle with 350-foot radius is 8.8 acres. You put roads and pipeline easements in there, and you've got probably a dozen acres that are impacted. In rural areas, hunting can be an issue, wildlife can be an issue, water conservation is a huge issue. So the surface owner should attempt to deal with those matters, those issues, the ones that particularly concern that land. And the current Oil and Gas Conservation Commission regulations require consultation. And the better operators, the better oil and gas operators these days are starting to consult. I battled oil and gas companies for a long time. I've had a lot of lawsuits against them. I'm starting to see a change of attitude, particularly with certain producers. I attribute that to one thing, and that's there are younger people in the industry. People my age in the industry had a certain mindset in the oil and gas industry. It wasn't good. Someone asked me before we came in here, are things getting better? Do you think the attitude of the industry is getting better or worse? And I said, I think it's getting a lot better. That doesn't mean the impact is less. The impact is more because there's more drilling. But the attitude's getting better, and it has a lot to do with the younger people that are getting into fields that are associated with the oil and gas industry. So that's one point of optimism. So, what should you do if there is oil and gas development on your property? How do you protect the surface? What should you be concerned about? You should be concerned about air, water, and land. For air, be very concerned and talk to the operator. And if you own minerals, make sure that the operator complies with what you want. It's the separation from your property between the separators and tanks and your property. Volatile organic compounds coming off of those tanks make a lot of people sick. Unfortunately, there's very little epidemiological or toxicological data on it. So there haven't been a lot of cases in court, or there hasn't been a lot of legislation on point. But people get very sick from breathing those volatile organic compounds. And you particularly see it when there's a topographical differentiation where the tanks are high and the resonance is low, because those VOCs are heavy and they settle, heavier than air, so they settle, and people breathe them. Now, to some degree, that has been mitigated in areas like Denver, where the incinerators are required to be placed on tank batteries. In my view, that ought to be more universal, just than in major metropolitan areas. I see that as the biggest problem. So if you are in and about oil and gas development, that's one issue I would attempt to deal with. If you own minerals, you can deal with it. The second issue is water. Water conservation, for one thing. Fracking operations require a tremendous amount of water. And that can be mitigated by recycling. To recycle the fluids that come back after the frack and reuse them. That does a couple of things. Number one, it conserves water. The second thing, it conserves truck traffic. You don't have those extra trucks going out and sourcing the fresh water and then hauling waste away. It also minimizes the waste disposal, so it's helpful, recycling. The second thing that can cause a problem is water depletion. Water depletion can happen if there's produced water that's produced off the oil and gas formation while the wells are being drilled. If that depletes wells and groundwater, I'll mention in a second how to protect against that. So those are the principal issues. Water contamination can be an issue, and that's usually a function of how the waste is disposed of. How's the produced water, the water that's produced with the oil and gas, how is that disposed of, and how are the oil field waste, like the flowback fluids from the frac operations, how are those treated, and drilling fluids, that type of thing. The land, minimize truck traffic. That's very important. Make sure that in your surface use agreement you deal with weed issues. That has a lot to do with how truck traffic goes across your property, whether trucks are washed before they go in, so they're not bringing in seeds from other weed species onto your property, and then having very strict rules about how wide the roads are, where they go, how they're maintained. So those are some of the land issues that you want to take a look at. Get baselines. Finally, I will say before someone goes on to your property, get baseline studies of the water. Hire somebody if you can yourself, rather than relying on the operator, to give you quality analysis and quantity analysis and get turbidity measurements. Because if you have groundwater, any oil and gas operation, not just fracking, can upset the groundwater formation and cause turbidity or suspended solids to get into the water, and it can damage your pump, damage your drinking water for a while. Quick summary, it's nice talking. Thank you.